Good morning or afternoon, depending on which it is for you, and welcome to our webinar. If you have questions, there's a simple two-step procedure. First, you click on the chat icon at the bottom of your screen. Secondly, you select Scott Solkoff, type your question, and send it. We have a lot to cover today, so if we don't get to your question, we'll get back to you. What you'll learn today, there's really great news. There are still growth areas in the practice of law, and elder law is a huge opportunity if you get in right now. What we will do today is to teach you how to capitalize on the opportunity while attaining great personal fulfillment in helping people who need your help. First, a few introductions. My name is Bob Henderson. I'm a fellow of the American College of Trial Lawyers, principal of RJH Consulting, working with small law firms nationwide, and co-founder of the Elder Law College. Our partner is Scott Solkoff. Scott is a board-certified elder law attorney, fellow of the American College of Trust and Estate Counsel, and principal of Solkoff Legal PA. Jan Friedland, our third partner, is also a principal in RJH Consulting, has a great background in law office operations, and a co-founder of the Elder Law College. We have a special guest today whose name is Felicia Pasculi. She's a certified elder law attorney and chair of the Veterans Benefits Committee of the New York State Bar. Now, why do we say there's such a great opportunity? Elder law is a huge new growth area in the practice of law. The changing population has created a growing niche for lawyers who provide critically needed services to the elderly and their families. The baby boomer population is just beginning to reach retirement age. There are 10,000 every single day, and that's going to go on for the next 19 years. The population of Americans over age 57, for example, is projected to increase to 100 million during the next 2 decades. This new demography is going to present novel challenges to traditional political, societal, medical, and legal establishments. For the legal profession, however, elder law presents huge, ever-growing opportunities for those who have the imagination and vision to capitalize on it. Today's reality is that the wealth of the nation is concentrated in its 57 to 75-year-old population, and people are living longer. This is scary. Government figures show that after age 67, 7 in every 10 Americans will need long-term care from some source, including nursing homes. This is also scary. Depending on where a person lives, the median bill for a private room in a nursing home today is $91,250. In practicing elder law, therefore, you're not representing little old ladies on Medicaid. It's profitable. It involves people with real means who can afford to pay for the protection they need that an elder law practitioner can provide. Elder law can also be a significant feeder for virtually every other area of practice. For example, by providing sage advice for a client's aging mother or father facing a crisis of aging, you will earn that client's everlasting loyalty for whatever other legal needs they may have. Contrary to many areas of practice with which you may be familiar or may engage, elder law is not confrontational. By practicing elder law, you will not only be providing a needed service, but you will be emotionally and spiritually rewarded in helping people who really need your service. Take a married couple with $500,000 in assets. If one of them goes in a nursing home, they'll be wiped out in no time. You can help them to preserve their assets and feel really good about it. And now I'm going to turn the program over to our partner, Scott Solkoff in Delray Beach, Florida. He'll give you an overview of how to become involved in an elder law practice. Scott? Reviewing Scott's screen.
But I want to hear Scott.
Can you hear me now?
Yes, thank you.
Okay, I apologize. Here I am. Hello, welcome. I'm Scott Solkoff. I've been practicing elder law for over 20 years, and I've been involved in educating elder law attorneys of all different experience levels, from beginners to very advanced practitioners. And I'm humbled by today's attendance. You're joined by hundreds of your colleagues across the country. We know very little about most of you, but all of you have one thing in common. You showed up, and that's a lot. You've taken that important first step to realizing a goal, and with that first step and then a plan and a system, I'm going to speak to you about the elder law opportunity and the method to become proficient and successful quickly. We've identified 3 different requirements necessary to succeed in elder law. We're going to talk today about the important distinction between readiness and expertise, and how that mind frame comes into play as you rev up your elder law practice. I'm going to identify practical knowledge components in the practice of elder law, and the primary and secondary substantive components or practice areas.
You be ready.
And Jan and Bob, if you mute your microphone. Carefully defining this to-do list is what paves the way for success early on. So it's a matter of organizing the topics so that you can have a system that's ready to go and successful. I'm going to explain to you also Elder Law College and the tools that we've assembled to help lawyers break out of the rat race and achieve quick success in elder law. Our objective being today to allow you the tools to transition to a rewarding special needs and elder law practice as quickly as possible while gaining expert class knowledge, earning an income through the transition, because the recognition is that each of you is already in some practice of law, and it's difficult or impossible to just stop and go into a new practice of law. You're dependent upon that income to make it work. So we'll talk about how we find best to do that. And we also recognize that as part of that objective to transitioning to that rewarding practice, you have to have the confidence level to open up your doors and say, I'm an elder law attorney. You have to have confidence to meet with clients right away. So to do that, and understanding the 3 requirements of success, we start from the premise that there are 3 necessities that you must have in place before you can effectively start marketing and meeting with elder law clients. There's the substantive knowledge, the law, and the ancillary psychosocial knowledge. To say that one needs to know elder law before practicing elder law is both obvious and incorrect at the same time. Knowing elder law is too vague a goal. It's too general to have an achievable, measurable success. Instead, we want to have a focus list, a list of primary and then secondary practice topics so that you have an order of knowledge and then mastery. We call these first stage practice areas and then second stage practice areas. So I'm going to define these substantive topics in a bit. First, understand also that our second requirement for success is the practical knowledge, the how. How do I apply the law? Which document when? How do I run the business? How can I most successfully market my business? And that's not enough. The third requirement is to successfully launch your elder law practice by having an expert on call, a go-to resource who is there when you have a question. So, readiness versus expertise. You've taken the first step to become an elder law attorney by attending this webinar. Some of you have taken other steps prior. If you are not somehow invested in becoming successful in this goal, you wouldn't be here. And what is that goal? Well, each of you might describe it a little bit differently. Your goal, you might say, might be to become a leading expert in the field of elder law. Your goal might be to make a lot of money. Your goal might be to have a more harmonious, less stressful job. Your goal may very well encompass all of these things. I submit to you that it will go easier for you and you will achieve your goals quicker if you start with the goal of readiness. Readiness is defined as the state of being fully prepared for something. In this case, launching an effective, respected, and profitable elder law practice. So to do that, one of the great barriers for many of us is we want everything to be just right. We want 100% confidence before we open the door. We feel like we have to master each subject because of our fear and concern that we won't be able to do the right thing by the client. But you can't let the perfect be the enemy of the good. So there's a process by which you go through to be ready before expertise. And readiness means you can open the doors. Expertise is the matter of taking that over time. There's a shortcut to one's expertise. We'll talk about that, but there's no instant solution, of course. So your goal is to be ready and capable, not necessarily an expert just yet, but have your expert in the wings so that they're there for you when you need it, so that you ultimately can confidently represent clients when they come in the door with expert guidance that you will have to not only answer the questions that come up that you might not know intuitively, but so that you can also master the practice over time. So we talk about first stage practice areas, and these are the topics that are the necessities before you open up your door. In your short-term goal becoming an effective, respected, and profitable elder law attorney, you must be organized in your approach, and you, more than, say, a law student right out of law school, have to be more organized in your approach because you have so many demands on your time. You have the existing demands of your existing practice. Some of you have families that have other pressures, all good, on your time, and it's hard to juggle. So organizing a process by which you're going to attack it is absolutely essential because the pool of elder law topics is just overwhelming. If you look at the list of all of the different things that elder law attorneys do, it's too daunting. There's no way, and many a lawyer has been stymied or slowed to a crawl just because it's hard to prioritize what knowledge is needed first. So we've identified three major categories that form first stage practice areas. First stage practice areas are the broad topics with which you must be proficient before launching your practice. This is the basic skill set, upon which more advanced knowledge then builds. And by organizing this pool of available information and then focusing on just these three categories, you're going to have just made your goal a gazillion, is that a number? A gazillion times more achievable than not knowing what to study first and in what order. So your first stage practice areas include incapacity planning and solutions. It forms the first of our first stage practice area categories. This is where powers of attorney, advanced healthcare directives, and certain kinds of trusts fit in. For clients who are well and fine, the elder law attorney is preparing them for what should happen if they become mentally and or physically incapacitated. And many clients will come to you when dementia is already present. And at all different stages, you may have people in the early stage of dementia who are very capable of fully participating in a meeting, and you may have people even in the most advanced stages of dementia with whom you're going to have to work to the extent possible. And you're going to have to find solutions and present solutions to provide necessary assistance. Incapacity planning and then dealing with incapacity is a fundamental component of an elder law practice, a first stage practice area. Post-mortem estate planning. Another first stage practice area is the what happens after I die part of the practice. This is akin to traditional estate planning, wills and trusts primarily. There are different kinds of wills and trusts and other ways of passing on one's wealth. The elder law attorney must be proficient in post-mortem estate planning, and there should be a list of key documents made which are examined and understood by you prior to your launch. This is necessary information before you open your door. Some of you have worked with trusts before. Some of you have heard the term but would be hard-pressed to define it. Because I'm going to be using that term through our presentation, I want to define it for you this way. Even for those who are well familiar with a trust, I'd like you to think of a trust agreement as an artificial legal entity, kind of like a corporation. And just like we as lawyers might create corporations on paper and they're signed and we breathe life into them, so too with a trust agreement, which is again an artificial legal entity. The lawyer puts it to paper and it can own things. It can even have its own tax ID number, etc. And we use trusts often in estate planning. So post-mortem estate planning is, how do I give away my stuff after I die? It is the traditional component of a traditional estate planning process. The elder law attorney is more than proficient in post-mortem estate planning, but you're going to see in a moment that the emphasis on post-mortem estate planning is different in the way we patch it all together with the lifetime needs of our clients. So then there's the third category of first stage practice areas. We would call this lifetime planning for long-term care. Traditional estate planning attorneys define their practice around what happens after death. Their key tools are the will and the trust. The successful and respected elder law attorney can do all of that, but the focus is on the lifetime needs of the client. How is mom going to be able to stay at home when she gets older? How can we afford $8,000 a month for a nursing home with no insurance or little insurance to pay for it? How am I going to get the care that I need? My husband has Alzheimer's disease. How can I get help without getting wiped out? How can I remain as independent as possible? These are the core questions facing our age. These are the issues that press on families today, and it's only going to become more important tomorrow, as Bob explained. So, The elder law attorney does postmortem or traditional estate planning, but we first attend to the lifetime needs of our clients. That's a pretty awesome value proposition. It's what I do every workday. My tools under this category, well, incapacity planning and solutions, postmortem estate planning, lifetime planning for long-term care, and that underneath includes Medicaid, Medicare, VA benefits, insurance plans, psychosocial and practical resources, such as giving my clients the tools they need when faced with a nursing home contract or an improper discharge, or how best to gain admission to the right facilities. Lifetime planning for long-term care is therefore the third of the first stage practice area categories, and these are not presented to you in their importance. These are your three categories that you must master prior to being able, or these are the first three areas that you must become proficient in prior to opening your door. And by knowing the right documents and programs under each of these three categories, you achieve the substantive knowledge requisite to starting your practice. Then we have our second stage practice area categories. Think of these as the practice areas that are desirable, but not essential to opening your door. You will want to add them and master them later, but your time is valuable, and there must be an order to your process of launching your practice or you will fail. You must focus on first stage practice areas first. You must be conversant in second stage practice area categories, but you need not become proficient in them right out of the gate. These can wait. You can choose to add them at any time. In the meantime, this is work you can refer to other lawyers, which will only serve to endear them to you and make them more vested in your success. So second stage categories starts with estate and trust administration, which is frankly relatively easy. It's probably the simplest part of my practice. It can also be lucrative. There are two main types of administration, lifetime and postmortem. When using wills, we often refer to postmortem administration as probate. Administration can also include the organization, protection, and disbursements of non-estate assets, such as life insurance and retirement accounts, with or without beneficiary designations. Estate and trust administration can also mean a representation of trustees of trusts where the creator of the trust is alive or deceased. You can start an elder law practice and do very well without ever handling fiduciary representation, probate, or trust administration. That's why this is considered a second stage practice area. Most elder law attorneys do this work, and you should also become proficient in estate and trust administration, but it is not necessary right away. If you're going to become an elder law attorney while still making money and doing your other work, you will need to prioritize what it is going to take to open your doors the right way. And you do not have to have all elder law practice areas offered on day one, or it will put you off to the point often of failure or, again, slowing you down to a snail's pace. So this is a good one, estate and trust administration, but we feel it should come only after proficiency in first stage practice area categories. Now, estate and trust administration, again, is relatively easy. Guardianship is a court process by which a person is appointed to exercise the rights of another, usually incapacitated person. And this is the opportunity for most elder law attorneys. It's often the only court work that's done. Many elder law attorneys do not litigate, but guardianship brings the lawyer into court for the court to do usually an involuntary delegation of rights to from an incapacitated person to a competent, capable guardian, sometimes called a conservator. And that guardianship process is necessary for people who become incapacitated and who do not have the proper solutions and supports necessary to solve their current or future needs. I love guardianship work. For me, it's really interesting. Some people hate it. I marvel at the work of guardians. They have to be expert in almost everything, professional guardians. They have great fiduciary authority, and you as the attorney are representing usually that guardian and giving them the legal counsel they need to carry out all of their responsibilities. This is the time to still be able to go to court, have that collegial relationship with the local bar. And if you want, you can handle contested guardianships too. Some attorneys really enjoy that and find that satisfying. But this, again, guardianship is viewed as a second stage practice area category. There are many very successful elder law attorneys who do no guardianship work. You may find it helpful and desirable to add it to your practice, but regardless, you've got to get the first stage practice areas down before you can start adding these categories. You're going to be knowledgeable about it. You're going to know enough about it to be able to talk conversantly, get them to the right attorney if you're not handling it yourself, but you do not need to become proficient in it just yet. Special needs trusts are an interesting creature. Really, they belong on first stage and second stage because there's different types of special needs trusts. Special needs trusts in general are trust agreements that are specifically used to help people to retain or qualify for need-based government benefits, usually SSI or supplemental security income and Medicaid. And that allows the person to qualify despite the fact that they have money in their trust. There are different kinds of special needs trusts, actually many different kinds, that are used in an elder law practice. The main distinction that you should know right now is the difference between first-party special needs trusts and third-party special needs trusts. A first-party special needs trust is a trust created with the assets of the person with disabilities themselves, and they are the sole beneficiary of this trust, and there are special rules regarding how those trusts are administered that the elder law attorney is proficient or expert in. First-party trusts can be considered a second stage practice area category. Not all elder law attorneys do first-party special needs trusts. These are usually, by the way, the trusts that are used when a person has been injured through medical malpractice or a PI case, or perhaps they receive an inheritance. They're coming into money that's going to disqualify them from their necessary need-based benefits, and you create that first-party trust to solve their problem. As I say, many elder law attorneys rather, do not have a first-party special needs trust practice, but I think it's also fair to say that almost all attorneys who do first-party special needs trust planning are also elder law attorneys. Now, third-party special needs planning is when the assets of another person are used for the benefit of the person with disabilities, and different rules apply to the construction and administration of those trusts. And I would consider third-party special needs trust planning as a necessary first stage practice area component, and it's something that we in Elder Law College address up front. This is, for example, the very common instance of parents for whom you're doing planning wanting to provide for their child with a disability. And if that child with a disability receives their inheritance outright without any special needs planning, they stand to lose their eligibility for their Medicaid or other need-based benefits. This is something an elder law attorney can solve for the client. Facility resident rights is another second stage practice area category. This can be a very important part of an elder law practice, but again, it's labeled second stage because it can wait. Facility resident rights include such issues as unlawful discharges from a nursing home, or switching that resident from one room or one part of the care center to a lesser part or part that looks or feels different. It could be a facility illegally cherry picking their admissions. Nursing homes, for example, make more money from certain patients more than others. And your client doesn't know about this. Your client's not savvy about how to work that system, but you can be. And by being able to give them the words to use, the guidance, you're leveling that playing field incredibly, and it can have a marked effect on quality of life. And I say this without exaggeration, sometimes life and death. Facility resident rights might also include a tactic used by facilities to force guarantees of payment by family members for their loved one. And you, as the elder law attorney, can help combat that. It might also include safeguarding the privacy and dignity of our clients who are in facilities. If you've been into a nursing home, you see sometimes the doors being left open, a person being changed naked while people are walking through the hallway. This demeaning, dehumanizing part of being a resident at a nursing home needs advocacy, and who better than the elder law attorney? So, and then other consumer advocacy positions that need to be advanced in nursing homes, assisted livings, and facilities, and similar facilities. These are all practice areas that the elder law attorney can become proficient in and then master, that can bring great value. And I'm not suggesting by any means that this is not important by placing it in second stage. These are all very important practice area categories, but it is not essential for you to understand the full gamut of facility resident rights in order for you to be able to open your doors. That's something that you need to be facile in, comfortable with, be able to speak about and address the issues, but you yourself do not need to be the one right away to solve those problems for the client. You need to open your doors first and start the practice proficiently, and then start mastering the second stage practice area categories. And then a fifth second stage practice area category that we've identified would be dealing with insurance and health plans. This can be another very important aspect of an elder law practice. It includes such matters as evaluating Medicare supplement policies, advocating for your insured client's rights on a long-term care insurance policy, counseling your client on the practical differences and consequences to, say, a Medicare HMO as opposed to traditional Medicare, which you're going to know and understand. Understanding more detail in the Affordable Care Act and how that affects your clients. This is an issue that might be addressed. For example, say you're counseling a client who comes to you and has what's known as a Medicare Advantage plan, also known as Medicare Part C. It's what most people say when they say, I have a Medicare HMO. Well, you are going to be ultimately knowledgeable in counseling a client that their free Medicare HMO has some benefits and some disadvantages, and you want them to understand those advantages and the disadvantage, for example, that it may restrict their healthcare choices, and how, and whether that really matters to this particular client and how much. So weighing the equities. Another valuable service of the elder law attorney, but not one that you need to have down before you open your doors. So once we understand the substantive knowledge, the law, then of course there comes the practical knowledge, creating that well-oiled machine so that your business runs well and you're able to do good with your knowledge of law. In order to do any good, the phone's got to ring. You've got to have people calling you. So knowledge about the elder care market, how best to speak to the elder care market, becomes very important. And then once you have an understanding of how to get that phone to ring, then it becomes a matter of keeping that phone ringing so that you have an ongoing system that achieves success and allows you to exceed the expectations of your clients. We call it representing success with successful representations. It's inspiring tremendous confidence in your client that you are the resource, that you can make things happen, that you can fix so many of these problems, that you can level the playing field for your consumer client in a long-term care system that's built on making as much money as possible from that client. And then once you get that phone to ring, you've figured out the practice systems to get the phone to keep ringing, you're going to have to run that successful special needs and elder law practice. These are the practice systems, which means success or failure to your business and your personal reputation. This includes your intake process, the outline and the flow of consultations, pricing, time management, checklists, the set correspondence that goes out to a client at which particular point in the consultation and in your representation, product development. And by that I mean that in your practice, you need to be able to speak and package your services in a way that it's understandable, not only to your elder clients, but to their children and to the referral sources that get you there. So I want to talk to you now about a third component that we've identified, and that's now you've got the substantive knowledge, the law. You're going to have down the practical knowledge on your master to-do list, and then there's the necessary component of knowing that you've got somebody in the wings to call. And I'm going to address that, but first I want to turn over the microphone to my friend and colleague, Felicia Pasquuli, who happens to be in town in Florida from New York, and has a wonderful, very successful practice in the greater New York City area. I asked Felicia, I put her on the spot since she's down here. I told her that if she wants to go out to dinner, she's got to speak to you about what she does. And I thought it might be helpful for you to hear the experience of how another elder law attorney got into the practice and drew satisfaction. Felicia?
Thank you, Scott. I'm sort of happy to be down here in the beautiful state of Florida. It's a lot warmer than New York. First of all, I do want you all to have the courage to take a leap of faith. I think most of you are actually in a better position than I was when I started. I was in my late 30s when I decided to go to law school. The reason why I decided to go was because of a personal experience with my father, who was a disabled World War II veteran. So before I went to law school, I tried to do whatever advocacy work I could with 3 children. And I think that's something that may be helpful in order for you to secure clients. If you do some sort of advocacy in your spare time, volunteer, for example, with the Alzheimer's Association, get to know the local chapter of AARP, certainly get involved with your local bar association. All of that will help to develop a client base. I became an elder law attorney, as I said, because I wanted more credibility as an advocate. Didn't know as much about specific areas of elder law practice. And I totally agree with Scott on the order in which one should begin a practice. But I can tell you that the one thing I didn't expect, or the reason why I didn't decide to become an elder law attorney, was money. However, in fact, it has provided a very lucrative living for myself. And that was just an additional bonus to practicing. I find elder law to be gratifying, fulfilling. I think one of the reasons why it is lucrative is because of the clientele that you're dealing with. If you notice, older people always pay their bills. I never have an issue with receivables. They are also extremely appreciative of someone who actually listens to what they're saying and gets in as much experience or as much knowledge as possible before proceeding. One of the other observations I had after listening to, I guess was Bob, the initial part of the talk, was that Bob concentrated on really the explosive growth in the field, the fact that we have demographics on our side. However, there's another part of the population that we didn't talk about, and that was the people with special needs. In fact, not only are we living longer, but disabled people are living longer. And we also, unfortunately, have an extreme rise in the psychological and emotional disorders like autism. When you talk about a disabled child and you're also dealing with the planning for their parent, you're talking now about guardianships, the child's eligibility for benefits, housing and educational rights, and also the parents' post-mortem planning for them. And that gets to where Scott was talking about maybe third-party trusts, or even a way for a parent to preserve money if they suddenly need a public benefit like Medicaid. So that's just a whole other area of growth. One tip that I might give on how you can best educate yourself before the client even walks in the door is to send out a questionnaire, a comprehensive questionnaire to them. Have the questionnaire include personal information. Who are they? Who's their spouse? Are they a veteran or not? Who are the members of their family? How's their health? What diagnoses may they have? What's their income, their resources, their expenses, their healthcare coverage? I kid around with my clients that I'm really not being nosy. I just want to be able to help them with having as much information as possible on hand. So they really do. It actually turns out to be a good exercise for them too, because they've probably never organized all of that information. Why is it helpful to me? Well, I'll give you a couple of simple examples. I can have a family come in and talk to me, say children come in with their parent. They're telling me they're coming in for basic asset preservation planning. So I always make sure people have advanced directives, powers of attorney, healthcare proxies, maybe a simple will. What they didn't talk to me about was the fact that their parent had been diagnosed with dementia. How did I know? Well, I asked about the healthcare issues on my questionnaire, and I even asked what medications people are on. Because if I see something like an Alzheimer drug, right, with, because I have Alzheimer, I can't think of one off the top of my head, Namenda, for example, then I know somebody's got an issue already, and that may require a whole nother avenue of planning. Another thing that I found is extremely important is whether or not your client is a veteran or the spouse of a veteran. Because as I've done in the past, and I found out that the client is a veteran, and then I asked, well, do you have a service-connected disability? Then I ask, where did you serve? Let's say you have a large segment of the baby boomers who are Vietnam era veterans. If they were in country and I see that they have diabetes and I find out that they have never made a claim for veterans benefits, I ask them to do so and refer them to an expert on that, because they are presumptively determined to have developed that illness while they were in the service. Well, after that, your clients think you can walk on water. You can give them a simple piece of knowledge like that, and they can take it and run with it. So, I've found, as I said, there's that leap of faith. When I first got out of law school, I worked for an attorney that specialized in real estate and estates. So I got to know a little about estates and kind of had to do it by the seat of my pants after that. The local bar association was helpful. A mentor was extraordinarily helpful, and I agree with Scott, you've got to get a hold of that. One of the other benefits of being an elder law and special needs attorney is that I feel that we probably are in the most collegial area of the law. It is just astounding how generous even the busiest and most successful of elder law attorneys are with their time when you have a question. I can tell you from my own experience, I must field a phone call a day from another elder law attorney that has a question. Also, I found that when you belong to your local bar or the state bar associations, then they generally have listservs where you can ask questions and get answers or find out about pressing issues that are, relevant right now with elder law. So I don't know if there's anything else you want me to say, but
you could
I
probably
hope that was helpful.
talk for a day and give information about what it means to be an elder law attorney and how you learn it. And what this folds into is you got so many different substantive practice areas, and then the practical application of how you're doing it, what documents to use and when, and how your practice system should work. And it will take, you join the bar associations, you'll read books. I'm reminded of an attorney who came up to me after a lecture and said, Scott, I've gone to these state bar elder law meetings. I've joined this particular national organization, and I'm working really hard. I still don't feel confident. I still don't feel like I have what I need. So I asked him, Jason, do you go home after these seminars and look over your notes and read them through? Yes, I do. And I have the book. I write the book, so I think it's a very good book. But it's not enough to know how to do it. So having that expert on call is necessary, but you must prioritize what you need to know first and what can wait. After learning the law, you need also to learn how to do it, which document, etc. So with an expert's guidance, which might take someone else years to learn the different substantive practice areas and the how do you do it, could take weeks or months. Having somebody guide you and show you that. Knowing what's extraneous and what is essential is often known only after years of practice. So someone without that knowledge will find themselves working very hard, but having a very poor return on the investment of time. The attorney without a dedicated mentor is like the investor who is earning 0.25% on their money, and the attorney who's got that mentor is like the attorney who is given the winning lottery numbers. It's like winning the lottery. It's a fast-paced, much quicker way to master the practice. And if you're already busy, maximizing your time is one of the most essential components of how to make it work. So apprenticeship remains the only method, in my view, of mastering an existing discipline. And practicality dictates that you get up and running quickly, not after years of apprenticeship. And you want to be able, therefore, to not only have those substantive practice areas understood, identified, and coordinated in terms of a plan of how you're going to tackle it, but then have your experts secured and to get you through it, and to be there on an ongoing basis so that those experts are there. Keeping your experts means having an ongoing and mutually beneficial relationship with the right group, bringing in a new or other expert as needed. And the principle of this expert on call is a return to mentorship that attorneys used to do before they were practicing. It's a comprehensive process, or should be a comprehensive process of transferring knowledge from an expert to an apprentice, as opposed to, for example, going to a seminar and having one attorney speak on one topic, the next attorney in the next time slot speaking on another topic, all of which are very helpful, and we have some incredible speakers in the field, but they're not sewn together in a way that's going to form a system for you to learn how to become an elder law attorney. So transferring knowledge in the right way with a comprehensive process is what allows the expert to move to the apprentice that knowledge, and then the apprentice soon becoming a master in her own right. So I hope you have found this helpful. And now I want to go back to Bob Henderson, who will explain the rest of the story in our small time remaining today. And then we'll be able to take some questions. Bob?
Thank you. Thanks, Scott, and thanks, Felicia. As Bob said at the beginning, there is clearly a growing need, and this is the right time to establish yourself in this practice area. And after what you've learned in the last hour or so, you'll agree that yes, transitioning is achievable with the right knowledge and tools, which is why Scott, Bob, and I founded the Elder Law College. The college includes an intensive 3-day, 360-degree practice builder training program, as well as membership and support during transition and continuing throughout your practice. The intensive 3-day training covers the substance of the law, how to market your practice, importantly, how to price your services, how to manage cases, and advice on transitioning your practice. Membership provides online tutorials, the document library, a listserv and regular Q&A teleconferences, marketing and business management consultation, and much more. Our next 360-degree practice builder program will be in San Diego, beginning with dinner on April 14th and continuing the next 3 days with intensive class time. Our class size is limited to 15 students. That assures not only an effective learning environment, but also members' exclusiveness of expertise in their respective geographic areas. The tuition is $2,100 for the 3-day program and $150 a month for a 12-month membership, or a total investment of $3,900, which, is just one of our previous students experienced, can be recouped with your first client. We're providing an incentive to enroll today, and just today, by reducing the tuition by $200. As I mentioned, the class size is limited to 15, and we have had really remarkable response to this webinar, so the remaining spots in that class will fill up quickly. If you are interested and want to take advantage of the discount, simply use the link displayed, which we are also sending to you through the chat function. If you have questions or would like the link to register after today, please email Bob at the address on your screen. Thank you so much. We're going to turn the seminar back to Scott to answer as many of the questions you submitted during the webinar as time permits. Scott?
Okay, thank you. Thank you, Jan. There's, let's see if I can pull up the questions. Well, one of the questions is how do I charge for this service? How do I charge for my services? And the answer, of course, is it's going to depend on on a number of factors. But we do talk about a pricing system and different ways of doing that. It has to do with also how you productize your services to make it understandable to the client, so that that product can then be explained with its value proposition and then the fee. And I find that fees are hardly ever the issue. It's the value proposition properly explained is so profound that that's not the issue. The question, another question is, I'm a tax attorney, very busy on April 15th. Yeah. Do you have other seminars where? This is the program that's scheduled right now. Our prior program in Orlando, which sold out very quickly, was successful. We have the San Diego program. We will have more, but this is the one that's scheduled now. If you can't make this one, stay tuned. Next question. Does the elder law seminar cover Florida law? If not, how is it taught if covering many states? It's a very good question. Elder law, most of the principles are national in scope. The laws, Medicaid, for example, is a state and federal program. There are state variations that are significant, but there are more similarities than differences. So we teach Medicaid from a national scope and then talk about how you patch that together with the state variations. Also Medicare, VA benefits, 100% federal. Trust law and estate planning is mostly common law as adjusted by statutes in the state. So you'll find that this national approach to elder law is extremely helpful, but it does need to be supplemented with state knowledge, and we'll talk about, we address how that gets done and how you make that happen. There's another next question. Have you ever seen elder law attorneys incorporate other special needs services such as school advocacy? Have you, Felicia?
No, I think that goes to what you talked about earlier. You can't be expert in everything. And what I found was at first my practice was comprehensive and included, even as NAIL law, National Academy of Elder Attorneys, claims elder law includes 13 different areas or more. So I think the important thing is you can't probably do both well. What you have to do is recognize the issue, and if it does require a specialization, to refer that client to an attorney that specializes in educational law. So I think it's either you concentrate in one or the other, but you have to recognize it.
Yeah, I agree with that. In fact, one of the students that we've taught was doing 100% school advocacy, and for a number of reasons, very successful, mind you, an attorney in a northeastern state, but ultimately wanted to move into elder law. And I would say that it is possible to do both in your practice, but I don't know, based on what I know of school advocacy, that one attorney will have the time to be able to do it all. So that's something that you can incorporate into your office, but it's certainly not a primary tool. Next, can we get CLE credit for attending the college? Yes. Next, if you already have a strong knowledge of the elder law substantive issues, does the Elder Law College 360 still provide benefit? Specifically, I'm more interested in the marketing aspects of the practice. A big part of the 360, we do spend quite a bit of time on marketing and how to get your practice up and running quickly. But I would say that more experienced elder law attorneys do not attend, or it's not designed for the more experienced elder law attorney. We will be providing more advanced programming in the future, but this particular course that's being offered right now is for attorneys who want to get their elder law practice up and running. Next question. Do you get significant income from referrals By that I mean referring things like MedMal. You can get significant income from referrals, and it's one of the ways I can tell you that my largest referral sources are other attorneys. And for many reasons that you'll learn. So yes, the answer is you can get significant income from referrals, and you can make them very vested in your success. Next question. I just want to be able to competently draft basic documents, wills, powers of attorney, living wills, healthcare surrogate, designation of preemie guardians. Is this conference overkill? No. You will find that you may say to yourself, I just want to pop out some basic documents. But mind you, if you're just selling documents, you're commoditized. You're not doing enough, and it's not going to work in the long run. You can do it on LegalZoom. So you want to be able to show that it's your advice and counsel on how it all wraps together that is your greatest value, and it'll take your practice from a commodity on up to a very valuable practice to your clients and to you. What is the document library? Is it a drafting software? We give you the editable documents. You're not kept captive in any particular program. On average, how long will it take Elder Law College graduate to be up and running, taking in new elder law clients? Once completing the seminar and getting competent on the first stage practice areas, we find that after the 3-day program, our members are capable of opening up their doors, so long as they have all of those components in place, including that resource in the wings to call and ask questions of. Support staff needs. Yes, those are addressed at the program too. I can't get into it today. Do you see many attorneys transition from family law? Yes. Most of the attorneys on this call today, I don't know a lot about you, but I suspect that you are involved in practice areas that you are feeling stressed out, burnt out, and perhaps not getting the satisfaction that you want or deserve in your practice, the reason why you originally went to law school. Elder law is not, there are ups and downs. You deal with a lot of death and dying, but the reward of helping people with that death and dying is incredible. And I think you'll find that there are many attorneys who are moving from other more stressful practice areas to a less stressful, more directly rewarding elder law practice. I'm seeing many questions, and I can't answer them all in our time. It's past 2 o'clock, and you're welcome to hang up now, but remember that link. I hope to see you there. If this is something you truly want to do, you've made this major step in coming here, and I appreciate it so much. I'm honored that you have been a part of the program today, and we hope that we can help you further. So thank you very much, and if you have additional questions, please mail them to bob@elderlawcollege.com, and we'll be sure to answer your questions. Thank you so much for your time today.